Raccoon County, State of Utah, now in session. The Honorable John J. Walton presiding. You may be seated.
Good morning, ladies and gentlemen. Welcome to District Court. We are here this morning in the matter of State of Utah versus Jodi Hildebrandt, case 231501763. Mr. Clark and Mr. Sham are here representing the State of Utah, and Mr. Terry is here with Ms. Hildebrandt. We are scheduled for a waiver of preliminary hearing. Mr. Terry, it appears you have just handed the court a signed plea agreement.
That is correct, Your Honor. With respect to the waiver, Ms. Hildebrandt, we have had discussions. She fully understands the purpose of a preliminary hearing, what the burden of proof would be, and that she has the right to a preliminary hearing, but in conjunction with the entry of her plea today, we waive the preliminary hearing.
And in fact, there is a provision in the written plea agreement that operates as a waiver of the preliminary hearing. All right. Ms. Hildebrandt, I've been handed a written document, a plea agreement with your signature on it. Did you sign that document?
Yes.
And you did that to represent to the court that you have read the document carefully, that you understand what you've read, that you agree to all of the terms that are set forth in that written document?
Yes, sir.
You've had sufficient time to ask Mr. Terry any questions that you have about the agreement or its potential effect?
Yes.
Is anyone pressuring you to enter into this agreement, or is anyone promising you anything that I haven't been told about or that is not in the written document?
No.
Are you under the influence of alcohol or drugs today?
No.
Is there anything today that could interfere in any way with your ability to understand the agreement, its potential consequences?
No.
No physical condition, mental health, or emotional condition, nothing that could interfere with your present ability to evaluate the agreement and decide if it's what you're prepared to do today?
No.
You don't need more time, you're ready to go.
Yes.
Any further record, counsel?
Your Honor, the agreement contains a factual basis. There are a few details in the factual basis that we are not in full agreement with. However, this is a guilty plea. It is not an Alford plea. The factual basis sets forth facts that we agree with, that Ms. Hildebrandt agrees with, that are sufficient for the court to accept her plea with respect to the 4 counts to which she is pleading guilty. And so we ask the court to accept her plea agreement.
And apart from what is in the written factual base in the plea agreement, you have, I'm assuming, reviewed voluminous discovery. You don't dispute whether there is an actual or an adequate factual basis?
We do not.
All right, then. Anything else before the court receives Ms. Hildebrandt's pleas?
No, Your Honor.
Nothing for the State, Your Honor.
Then, Ms. Hildebrandt, how do you plead to count 1, aggravated child abuse, a second-degree felony?
Guilty.
And to count 3, aggravated child abuse, a second-degree felony?
Guilty.
To count 5, aggravated child abuse, a second-degree felony?
Guilty.
And to count 6, also aggravated child abuse, a second-degree felony?
Guilty.
The court finds that there is a sufficient factual basis. The court, in addition, finds that Ms. Hildebrandt's pleas are made knowingly and voluntarily. The court, therefore, accepts and enters those pleas, dismisses the remaining 2 counts. We are anticipating a PSI, although part of the plea agreement appears to be that Ms. Hildebrandt will not contest a prison sentence.
Correct.
Is that right?
That is correct. But we are asking for a PSI.
All right. Then the court orders the preparation of a pre-sentence investigation report and sets sentencing at 10:30 a.m. on February 20th. Anything else for today, counsel?
Nothing from us, Your Honor.
Nothing from us, Your Honor.
All right. Thank you. We'll be in recess.
Thank you, Your Honor.
First and last. Douglas Terry, T-E-R-R-Y. I haven't had much to say about this case prior to today because I didn't feel it was appropriate to do so until today. Ms. Hildebrandt, my client, has pled guilty today to 4 counts. She has done so because she takes responsibility for her conduct in this matter. Her guilty pleas, she decided to plead guilty before Ms. Frankie entered into her plea agreement or agreed to cooperate with the state. She has pled guilty because she did not want these children to have to testify. She takes responsibility. And it is her main concern at this point that these children can heal, both physically and emotionally. We look forward to sentencing. That's all I have to say today.
There are people all over the world that are coming out and saying that Jodi Hildebrandt has destroyed families, that she has hurt a lot of people. Has she seen this kind of the backlash that's happening, and what does she have to say about it?
I'm not going to have any more comment, nor is she, at least prior to sentencing. Thank you.
When will the sentencing take place?
February 20th. Thank you.
Can you share the terms of the agreement as far as how that pertains to sentencing, and is there a specific range that the court has agreed to?
She's agreed to a prison sentence, 4 counts, consecutive, the same as Ms. Frankie. Exactly the same as Ms. Frankie.
In Utah, there's rumors about consecutive sentences. How long could her sentence term be then? Could all 4 be consecutive together?
Ultimately, it's up to the Utah Board of Pardons, and I'm not going to speculate at this point how long she might serve. Thank you.
I'm Washington County Attorney Eric Clark, and I just have a brief statement that we'll read, and then we'll be happy to release this along with the signed plea agreement to anybody that requested today. So this morning, Jodi Hildebrandt pleaded guilty to 4 counts of aggravated child abuse. She will remain incarcerated, awaiting sentencing, which will occur on February 20th, 2024. As part of the plea agreement, Ms. Hildebrandt agreed to be sentenced to consecutive, as opposed to concurrent, prison terms for each of the 4 counts. One of the toughest things we ask victims of alleged abuse to do is testify in a trial against their abusers. We are pleased that in this case, and in Ms. Frankie's case, that won't be necessary. That both defendants will be going to prison without having to hold a trial. We're grateful to the multidisciplinary team that investigated this case. We have great law enforcement officers, caseworkers, Children's Justice Center staff, both in our area and in Utah County. Additional information about Ms. Hildebrandt and Ms. Frankie's cases, including redacted investigative materials, will be available upon request 30 days after sentencing of both defendants. For further information, please refer to the statement of defendant in support of guilty plea that was filed with the court this morning, and we'll be happy to make that available. Thanks, you guys.
Why were 2 of the counts dismissed?
So, in any plea agreement, there's always some back and forth in that, and in this instance, 2 counts were dismissed, and what Ms. Hildebrandt agreed to do was to not contest that for each of the terms there'd be prison, and that those would run consecutive as opposed to concurrent.
But why not all 6?
Well, so I think that's a fair question, and that's what, as a prosecutor, that's what you deal with every time you're handling a case, right? Is if our plea offer had been there is no plea offer, plead straight up to all 6, then the defendant has no incentive to go to trial. And we're not afraid of trials. We don't want to avoid trials. Trials carry some risk in that you don't know what the outcome's going to be, but more so when you have victims that are having to go through the trial process, that's difficult. And so if we can get a result that is similar, in Utah, there's the maximum penalty for second-degree felonies is 30 years. So if we had 15 counts, the maximum amount of time would have been 30 years. And each count carries a 1 to 15 years. So the difference in reality between 4 counts and 6 counts, in our calculation, wasn't enough to justify asking victims to go through a trial.
Part of Ruby Frankie's plea deal was to testify against Jodi Hildebrandt. That was like a big part of that plea deal. Does that mean that it's irrelevant now? She will not have to testify against Jodi?
That's what I anticipate, yeah.
When it comes to prosecutors always have to determine who they think is the more culpable party and co-defendants. Who do you believe is the more culpable party?
I'll be more comfortable speaking about specifics in the cases after sentencing, and then we wait for the 30 days to make sure that appellate time is run, and that's just us being super careful to make sure that procedurally we're not doing anything that can complicate a case down the road and overturn a conviction. So I'm not going to get into thought processes at this point.
Daniela with KSL 5 News. The defense attorney said that Hildebrandt chose to plead guilty before Ruby Franke made the decision to plead guilty. Is your office aware of the timeline there and which plea happened first? Which agreement happened first?
No, in that we weren't talking to both Hildebrandt and Franke, right? It was clear to us we knew that Franke was going to plead earlier than Hildebrandt. Thus, like, Franke's the deal that Franke pled to included her agreeing to testify against Ms. Hildebrandt, and also that we would not submit things to the parole board asking that she stay in prison for a longer term. So that was in Franke's plea. That's not in the paperwork that you guys will see for Hildebrandt's plea.
In Frankie's case, you agreed to stay neutral for parole board hearings. Did the same agreement happen with Hildebrandt or no?
No.
So there's I know we can't predict the future, but so the door is open for the Washington County Attorney's Office to go to Hildebrandt's parole hearings and say, we believe she needs to stay in. Okay.
That's a good question. So the answer to that is yes. More commonly, the prosecutor's office can submit a letter or submit things in addition to the pre-sentence investigation that might open probation parole. But there's always the option of actually going in person and being at those hearings also.
Aggravated child abuse in Utah is a second-degree felony. Do we need to look at these laws in Utah?
I hope so. And that's something that I've been in talks with legislators already about.
Thank you.
Is that as a result of this case?
Like I said, I don't want to get into my thought process on this case until we're further along. But I have been talking to some of our legislators. I have been talking to some of our legislators that are open to criminal justice reforms about the level of severity in Utah law.
When did those conversations start?
In the last few months. Thanks, you guys.
As for those cases, what is this one right
I'm not going to get into, again, I'm not going to get into my personal thoughts on this until we know that everything is done and the appeal time is run. Thanks, you guys. Have a great rest of your holiday break.
Thank you. Thank you so much.